Yes, get ready for the legal dictation containing 480 words at the speed of 80 words per minute. Let's start. 3, 2, 1, start. Even though the DMA has filled crucial gaps regarding disaster management in India, it still comes with its fair share of criticism. One of its drawbacks is the absence of a provision for the declaration of disaster prone zones. The states can play a more active role when such provisions are made, as this classification can help in mitigating the damages that will be caused. The Act implies that disasters are a sudden occurrence when in fact they can be progressive in nature as well. For example, epidemics can be considered as disasters despite conventional definition, as it does take thousands of lives in its way. Epidemics of dengue and tuberculosis cause a lot of havoc, yet no effective mechanism is place of combat it. New disaster management guidelines are underway, and one can only hope it incorporates provisions to overcome dysfunction of the current authorities and not oversee yet again the valuable role that the civil society, private enterprises, and NGOs can play towards building a safer India. Disaster management in India leading up to 2005 consisted of a reactive, relief centric, and post disaster approach. However, the passage of the Disaster Management Act in 2005 caused a paradigm shift in the conventional regime of disaster management and ushered in an era of disaster control focused on preparedness and mitigation. Originally, the Ministry of Agriculture of the Government of India was the designated nodal ministry of disaster management. The government simply called for the armed forces during and after disasters. But even they were often left grappling for directions, since their mandates and priorities are, after all, starkly different. The Bhuj earthquake of 2001, one of the most devastating in recent times, prompted the Gujarat government to become the next Indian state to conceptualize a massive reconstruction and rehabilitation program, followed by measures for long term capacity building of all stakeholders to fight future disasters. The Disaster Management Act was passed with the primary objective of preparedness, prevention, and early planning towards disaster. Its statement of objective reads that it is an act to provide for the effective management of disasters and for matters connected therewith or incidental thereto. The act received the assent of the President on 6th of January 2006 and is applicable to the whole of India. Briefly, it provides for a detailed action plan right to guide the central government through to the district and local levels to draw, implement, and execute disaster management plans The Act also provides for state and district level disaster management authorities responsible for, among other things, drawing plans for implementation of national plans. The Act further contains the provisions for financial mechanisms such as the creation of funds for emergency response, national disaster mitigation fund, and similar funds at the state and district levels. The Act also devotes several sections, various civil and criminal liabilities resulting from violation of provisions of the Act, including punishment for wrongful claim of relief. Stop. Yes, get ready for the general matter dictation containing 480 words at the same speed. Let's start. 3, 2, 1, start. I have also been fairly closely connected with the matter in the sense that I have attached great importance to this work and I have occasionally had talks with the members of the commission to find out how they were getting on. May I say that the criticism that has been made, I think, yesterday by an honorable member about the rather sorry result of their labors appears to me totally unjustified. I feel their labors have resulted in very substantial and very good results. They have labored under great difficulties, and in spite of that, they have proceeded calmly and steadily with their work and the highest judicial traditions. And the House will remember that the chairman of this commission is one of our most eminent and respected judges of India. We attached great importance to the fact that a commission of this kind must have men of the highest ability and integrity, and we were fortunate in finding such a man in Mr. Vradachari. Anything entrusted to a judge of that high standing with his lifelong experience of the bench is bound to be carried out in a judicial manner. The House can be sure of that. In fact, possibly if delays have occurred as they have, partly they are due to the fact that the Commission and the Chairman are anxious to preserve every type of judicial procedure and not to do anything which might even given any suspicion of hurrying through and not giving that opportunity which shouldn't be given. If the House could see the decisions that they have given, they are tremendously long 70, 80, or 100 pages. They have carefully given every opportunity and have come to certain decisions. Most of these decisions also I would like the House to remember or ultimately by consent. Now, the difficulty in dealing with such matters through, let us say, the income tax department, which is the normal way of dealing with them has been that they cannot deal with them both judicially and at the same time informally. They have to be formal, their rules govern them, and the people concerned do not like that particular process. They do not welcome it, they do not go there easily unless they are compelled by law to go there. They do come, at least relatively, with this reluctance to this inquiry commission because the inquiry commission can deal with them informally, can come to deal with them informally, can come to terms with them almost any terms that they consider just and proper, which the income tax department cannot easily do always in this manner. Stop over.